The fight over birthright citizenship was supposed to be settled forever, but a new legal twist connected to Trump just cracked the door wide open for a 2026 Supreme Court showdown. And trust me, the consequences could shake the entire nation. For years, this debate has simmered in the background. Some presidents talked about it, some candidates campaigned on it, and legal experts always said the same thing: the 14th Amendment is crystal clear. If you're born on U.S. soil, you are a U.S. citizen. End of story. But suddenly, most people's end of story has become to be continued because the political and legal landscape appears to be shifting in a way no one expected. And the moment former President Donald Trump brought this issue back into the spotlight, promising to push the boundaries, test the constitutionality, and take a direct shot at what lawyers have long considered settled law, everything changed. At first, critics dismissed it. They said it would never get traction. They said no court would even take the case seriously. But now, several years later, we're staring at a potential turning point, one that analysts believe could reach the Supreme Court in 2026. The idea that birthright citizenship, one of the most fundamental rights in America, could be re-examined by the highest court in the nation is something no one saw coming 10 years ago. Yet here we are, watching what looks less like a political talking point and more like a pathway forming toward an actual legal showdown. So how did we get here? And why are legal experts calling this one of the most unpredictable constitutional battles of our generation? It starts with the sheer political momentum behind the issue. Over the years, the debate has grown louder, more energized, and more polarized. Supporters of limiting birthright citizenship argue that the original writers of the 14th Amendment never intended for it to apply to children of undocumented immigrants. They say modern immigration patterns have created a situation that simply didn't exist when the amendment was written in 1868. They see this as a loophole, one that encourages illegal immigration, puts pressure on social systems, and sends mixed signals about national identity. On the other side, defenders of birthright citizenship argue the opposite. They insist the language of the Constitution is unambiguous, that the United States has always recognized just solely citizenship by soil, and that any attempt to change this would violate both the letter and spirit of the 14th Amendment. They also warn that removing birthright citizenship could create a generation of stateless children, trigger legal chaos, and undermine one of the core principles that separates America from many other nations. This debate has always been intense but theoretical until recently. What changed is that multiple states, advocacy groups, and political figures have been filing lawsuits, policy challenges, and constitutional questions that all orbit around the same central theme: does the 14th Amendment guarantee citizenship to everyone born on U.S. soil, without exception? These cases started out small, barely getting national coverage. But one by one, they began climbing through the legal system: district courts, appellate courts, and with every new filing, the momentum grew. Now, analysts believe one or more of these cases could create the perfect conditions for the Supreme Court to step in by 2026. And that's the part that has Washington buzzing. Because if the Supreme Court takes up the case, everything changes instantly. Nothing would be guaranteed, nothing would be predictable, and the entire country would be glued to every argument, every opinion, every legal interpretation. And here's where things take a surprising twist. Conversations inside political circles say that the court may not simply ignore the debate anymore. There's a growing belief among strategists and observers that the justices might actually be willing to hear the case, not necessarily to overturn birthright citizenship, but possibly to narrow, redefine, or clarify how it applies in modern situations. That possibility alone is enough to set off fireworks on both sides of the aisle. So let's imagine what that means. Imagine a future where the Supreme Court agrees to hear the case. Imagine the opening arguments, the historical references, the constitutional interpretations. Imagine the questions the justices would ask, the precedents they would revisit, the documents they would dissect, and the political ripple effect through every state in America. Imagine the tension as millions of families, immigrants, lawmakers, and advocacy groups wait for a decision that could redraw part of the American identity. And then imagine what happens if the ruling doesn't fully align with either side's expectations. Because here's the thing: many constitutional scholars believe that if the Supreme Court takes up this issue, the final decision may not be a simple yes or no. It may be something in between, something more nuanced, something that changes how the country interprets the 14th Amendment without overturning the idea of birthright citizenship entirely. One scenario legal analysts keep discussing is the possibility that the court could redefine the phrase subject to the jurisdiction thereof in a way that narrows who qualifies for automatic citizenship. That phrase has been debated for decades, but no Supreme Court ruling has ever squarely defined it in the context of modern immigration. If the court does choose to interpret it more narrowly, that alone could reshape how future citizenship cases are handled even without eliminating birthright citizenship altogether. Another scenario could involve the court sending the issue back to Congress, essentially saying, "We're not changing the Constitution, but Congress has the authority to specify certain conditions under federal law." That would ignite an entirely new political fight on Capitol Hill, with both parties scrambling to shape the new rules. And then, of course, there's the most dramatic scenario the one pundits cannot stop talking about, the possibility of a landmark decision that actually alters how citizenship is granted to children born in the United States. It would be controversial. It would be historic. It would be one of the most talked about Supreme Court rulings of the century. And whether you agree with the idea or not, the impact would be enormous. Imagine the headlines. Imagine the debates. Imagine the protests, the rallies, the political speeches, the international reactions. This wouldn't just be a legal decision, it would be a cultural earthquake. And as 2026 gets closer, the energy surrounding this issue only grows. More lawsuits. More petitions. More political messaging. More legal scholarship. More speculation. The entire conversation is slowly building toward something, and everyone can feel it even if we don't yet know exactly what the final moment will look like. What we do know is this: the question of birthright citizenship is no longer just a fringe debate. It's becoming a mainstream legal challenge that could force the Supreme Court to confront the meaning of citizenship in the 21st century. And the fact that this issue, long considered untouchable, is now being seriously discussed as a potential 2026 Supreme Court showdown, that alone is the stunner no one expected. Whether the court ultimately hears the case or not, the political pressure isn't going away. The lawsuits aren't stopping. The arguments aren't fading. And the conversation around the 14th Amendment is entering a new era filled with uncertainty, intensity, and massive implications for the future of America.